This is We the People News. Okay? Not an attorney, not giving legal advice. Educational purposes only. Anything I say or do, it's just my opinion. I'm hearsay, they're hearsay, everybody's hearsay. Even your attorney and judge's hearsay. Do you arm yourself with knowledge? Be able to protect yourself by any means necessary. Okay? Previous video was talking about two classes of citizens. Okay? 14th Amendment against the people and all that kind of stuff. Okay? The 14th Amendment citizens, when you really dig deep into it, and everybody likes to argue, but they just don't know how to read. And it's not a summer citizen crap. Okay? Get over it. It's just the way it is. Okay? That being said, let's look back into court laws. A court president, I guess, however you want to look at that, when they actually use documents with the people. Now, how often do you really see today documents, court cases that has the people? Okay, some of you guys already know. I say, I'm a man, one of the people that go by Diesel. Okay, I'm not going to tell them that is my name. I go by that name. Okay, let's go. Because your name is actually hearsay, by the way.
Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. If you haven't already, please go ahead and hit that like button, hit that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. Alright, so this is essentially the second installment of all 50 states holding the people are sovereign. So what I'm going to be doing again is I'm not going to be reading the whole entire cases of every case that I cite because I simply do not have time for that. But I will provide y'all with the case citation for you to go and read on your own. Give me 1 second, y'all. I'll be right back. All right, everybody, I am back. Now, I want to reiterate something that I've already said in a lot of my videos. If you really want to know what is going on, you're going to have to read old cases, because the cases today, the so-called judiciary, they have been compromised. So you have to go back in time and read the old cases, because I truly believe back then the judiciary really did their job back then. So always do your best to go and read old cases. If you can't find the cases, just go on case.law. And every case that you need from, if it was ever filed in your so-called state, is going to be on there. But anyway, let's just jump right on into this.
And I need to look that up as well. It makes it a little easier. But I second what he says, right? Back then, before we had attorneys and before we had administrative, we actually had a judicial branch. Okay? And even back then, once you went to court, you seen a judge. It wasn't really a magistrate. Okay? Magistrates was really popular later on, and they could be magistrates, but they may have went into a different name. Really, it's just a secretary. Okay? And maybe because everything's so clearly established back then, the magistrate was in some form of contract law. Okay? But it stayed away from the judicial branch. Allegedly, maybe. Okay? And, but this is all we have today. Everything's done by administrative. Even when you call them judges, we need to quit calling them judges, y'all, number one. Or call them out. Which jurisdiction we in? Is this a magistrate jurisdiction? Or not magistrate? Is this administrative? Or is this judicial? Right? Get them in that box right off the top. Get them in that box. Now, I haven't done it, but I'm going to start doing it, right? Because I want that jurisdiction clearly established. Are we in administrative or are we in judicial branch?
So, the case of Wells versus Bain, this is a Pennsylvania, well, this case citation is a Pennsylvania's case, but this is an Alabama, if I'm not mistaken, Supreme Court case that is actually citing the case. Let me go and look at the case citation just to be sure. Yeah, So this is an Alabama Supreme Court case that is citing it. So it says, in the case of Wells versus Bain, also cited by this court in City of Bessemer versus Birmingham Electric Company, involved the question of what method of the constitutional change was available as an alternative to the legislature's proposal of an amendment, construing a declaration of rights that is similar to that contained in our present Constitution insofar as it concerns the inalienable rights of the people to change their form of government in such manner as they wish. The Supreme Court of Pennsylvania said that at this time, right here in 1874, the Pennsylvania, according to this case, the Pennsylvania Constitution had no provision for calling a constitutional convention. This is what the Supreme Court of Pennsylvania at this time, 1874, held. It said, the words, in such manner as they may think proper, that is extremely broad. In the Declaration of Rights, embrace but three known, recognized modes by which the whole people, the state, can give their consent to an alteration of an existing lawful frame of government, viz., so here's the three right here. 1, the mode provided in the existing Constitution, or in other words, in a manner that they have prescribed to themselves in their Constitution. 2, a law as the instrumental process of raising the body for revision and conveying it to the powers of the people. I don't think I would do that if that means what I think it. If that means what I think it means. When they say the body, they're talking about the legislative body, if I'm not mistaken, and I wouldn't do that. Or 3, a revolution. Those are the only 3.
All right, and there we go again. I would go with 1 myself, really, because we used the First Amendment, and you can figure out which state of the amendment it is that you're allowed to petition and redress your government, okay, to your legislature, and use that. Now, I'm with him on the second one, raising the body. I don't want to give them more power, okay, but they have a tendency to actually start. Texas has over 400 constitutions now, revised constitutions. That's too many. That's ridiculous. Okay? And I think that's what they did, is they rise the body into the people. And I had to read that a little bit more, and not on this, but I am. Let's see. To it, the power of the people. I'm assuming what they're talking about right there, and I'm going to have to kind of read it and look up definitions of words and just kind of put the definitions together to get a full understanding. By the way, that's one of the easier ways. Get the definitions, write it across, and make it a whole complete book basically about that, right? Use everything on here, use the definitions, and write it all out. Okay, and that's what I'm gonna have to do on this. But I'm thinking. See, the original intent was all the amendments was going to be ratified as time progressed it on. But I think what the founding fathers meant, because they didn't trust government, okay, is that we became so knowledge and so free that they can amend to the Constitution to relax on some of the things, okay? Some of our state constitutions more relaxed on the warrants, or was at one time. Now they're just, I don't know, you don't even ever get to see the warrants. But that being said, that they can make it a little harder for government and police to actually get a warrant. I think that's what it is. Or revolution. Well, that's causing harm. But don't forget our founding fathers, that's what they did with the kings and queens, right? Brits, right? They petitioned their redress and grievance, and they kept doing it. They exhausted everything. Well, now they did a revolution to break away from Great Britain. And really, that's what you had to do. You had to go back into the old texts and the old books of what they did to the kings. Okay? Which goes back into petition. Texas is Madison Administrative Procedure. Okay? There's a couple of other states out there you got to find out on your own deal. And it's not easy to find out, by the way. Some of them is Jefferson Administrative process, to go through the process of your grievance of like getting rid of a judge or getting rid of a governor or and this and this and this. Okay.
Ways at this particular time in which that they could, the sovereign people of Pennsylvania could, change their constitution. The first two are peaceful means through which the consent of the people to alteration is obtained. Notice that they need your permission, they need your agreement, they need your assent, they need your consent, they need your authorization, they need your approval. The first two are peaceful means through which the consent of the people to alteration is obtained, and by which the existing government consents to be displaced without revolution. The government gives its consent either by pursuing the mode provided in the Constitution or by passing a law to call a convention. If consent be not so given by the existing government, the remedy of the people is the third mode, revolution. This is one of the reasons why I say everything the people did on January the 6th, 2020 or whatever, when they said they raided the Capitol or whatever you want to call it. Like, this is their government. You can't, what else you supposed to do? If you reasonably suspect that your public servants are tyrants and they don't want to leave public, like you're trying to do this peacefully and to avoid as much as possible bloodshed and loss of life as you possibly can, and they refuse to do that, what are you supposed to do? You can't sleep on your rights. So let's go to the next one.
And I think the judge kind of danced around on that and not really just call out, well, you use your First Amendment and petition your redress of grievance and do a remonstrance and get in there and say, hey, this is not okay. We're instructing you to get back in good faith with clean hands and an honor. Okay? And, or we're going to have to boot you out. And I don't know. Sit and think about that, y'all. And by the way, when you do this in writing and with all the people, it's the reason why we're allowed to gather as well. We're allowed to have meetings of the minds and talk about the petition. This is the reason why the rich people's passing things in, and not only they're bought and paid for legislatures, but they get a group doing it. We're not getting a group to do it. And that's causing us harm, loss, and damages, but not actually going through the petition the right way. Instead, we're going to go out there and hold picket fences out on the side of the street, and cops come and beat you up.
This is a new video. So we're going to do different states. Connecticut. The Connecticut Constitution may be amended in one of the two ways. First, any legislature may propose an amendment. See Connecticut Constitution Amendment, was that Article 6? Yeah, Amendment 6, I'm sorry. The proposed amendment must be approved either by 3/4 of the members of each house of the General Assembly or by at least a majority of the members of each house in 2 successive sessions, yada, yada, yada. Let's go on down here. Once so adopted, the amendment is presented to the people for their approval at the next general election. For their consent, for their assent, for their approval, for their authorization, for their sanction. To be effective, it must receive the support of the majority, yada, yada, yada. Here's the second one right here. This is the part that I want to focus on right here. Second, because they said it can only be amended in 2 ways. Now, y'all keep in mind that some of this stuff may have changed, but I'm trying to get y'all to focus on the people are sovereign. All these so-called public service or magistrates, all right? The public service magistrates, they're trustees, all right? Second, the Constitution may be amended at a convention called for such purposes. A constitutional convention can be called by either the General Assembly or the people. So if you're in Connecticut, you might want to research this stuff to see if this is...
And there we go, General Assembly. Okay, that's a petition. Okay, just in case people didn't know, that's a petition. You go in there and instruct them.
I think this is still valid. I think this is from like 2006 or 2016 or something like that. Let's go down some more. Preservation of judicial constitutional error may result in costs beyond those arising from the difficulty of correcting such an error. Such costs result when a judicial decision alters, or disturbs the state polity. A brief digression into our constitutional history and theory is needed to better understand this harm. A fundamental principle of American government and constitutions, including the constitutions of the many states, is popular sovereignty. Where are we at? In essence, popular sovereignty is the theory that in a free society, the people hold the power and the government has only the power the people delegated it, granted it, authorized it to do, so on and so forth like that. Explaining founding era understanding of Republican government. Go down a little bit more. Delegation of powers occurs through the adoption of a constitution, which establishes the government and delegate the powers among the branches. Through this delegation, the people may reserve certain rights to themselves, limiting the government's power to act in particular areas. Also central to popular sovereignty is the people's ability to alter or abolish the established government, a right they exclusively hold. That means nobody else holds this right. It belongs exclusively to the people. It doesn't belong to the judiciary, it doesn't belong to the legislature, and it doesn't belong to the executive. That is, only the people and not the governmental institutions they have ordained can alter the structure and powers of government. The colonial citizens of Connecticut were no strangers to the ideals embodied in popular sovereignty. In fact, evidence dating back to the 1630s. Look at this, how old this is. To the 1630s demonstrates that the populace of the Connecticut colony adopted popular sovereignty principles.
All right, we're going to go ahead and end it there. So I hear a lot of people complaining about qualified immunity for officers and all that. Well, we need to get our legislature to issue when they enter a contract, that they waive it. Okay, there's been a couple of other videos that once you sue them, right, they waive their immunity and all that kind of stuff. But it's a booger. All right, and especially as corrupt it is. If you go through everything the right way, how they have it designed, especially if you're pro se or whatever you want to say, it's already a battle. And there we go again. You're going to have to go through the court system and even to your state, right? To the highest state Supreme Court, the appeals office, right? But if they don't see it your way and you see all these things they're doing wrong, then you take all that document and you put it in your petition and you tell them it's time to people, it is time to abolish the judicial branch and rebuild it and get back to the old judicial branch. And I think it'll go a long way, even if they don't abolish the judicial branch, get rid of the 1947 Administrative Act, period. But it takes you and I working together to do so. We the People News. Bye, y'all.